Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 3 of our new program entitled The New Era QME, and have a great program for you today, one which is going to provide you with several new tips and suggestions that you can implement with your very next QME report that will dramatically improve both the content and the quality of your report. When I refer to the quality of your report, I'm referring to the ability of your report to actually resolve disputed issues. And let me just reiterate that the purpose of this program is to help you succeed as a qualified medical evaluator. And before we can succeed as qualified medical evaluators, we first have to survive as qualified medical evaluators. And that's going to become a tad difficult in the very near future as the Division of Workers' Compensation ramps up its new program of report review and report surveillance. And we talked about that at great length in our first 2 sessions of this program. Now, in today's program, I want to share with you where the Division of Workers' Compensation is going and how they're going to start taking a new and more in-depth look at our reports in the very near future. You know, I read recently that the Division of Workers' Compensation recently hired its 17th full-time report review staff member. So the Division of Workers' Compensation has 17 full-time staff members whose job it is going to be to review your reports and to review my reports and to review all of our reports and to reject those reports that don't actually resolve disputed issues. And this whole new flurry of activity is based upon the recent state auditor's report, which found the Division of Workers' Compensation lacking in several areas, not the least of which was that the Division of Workers' Compensation has done a poor job policing and training qualified medical evaluators on how to produce what they refer to as high-quality reports. So I want to dig into the state auditor's contention in even more detail in today's discussion and show you how you can use the state auditor's criticisms of the Division of Workers' Compensation to more expertly draft and compose the opinions and conclusions in your report so that your reports are absolutely pristine in the eyes of the readers of your reports. And specifically with regards to the state auditor's report, which was dated November 2019, let's just review and refresh our memory that the state auditor accused the DWC of not ensuring, in other words, failing to ensure that QMEs produce high-quality reports, even though they're required to do so. The state auditor stated that the department has not ensured that QMEs produce high-quality reports that provide medical evidence to help judges and others resolve disputes timely, and it has not tracked when judges rejected reports that failed to meet standards such as accuracy or completeness, and these are not the only standards that the Division of Workers' Compensation is newly going to begin monitoring and tracking. And the state auditor's contention about the DWC's failure in this area has led to their conclusion that poor quality reports delay the resolution of disputes, delays the receipt of benefits by injured employees, and that further delays increase costs for employers involved in the disputes. And all of these accusations are true because QME reports that fail to resolve disputed issues create huge delays. Did I say huge delays? When I say huge delays, I'm saying that low-quality QME reports can sometimes increase the resolution of disputed issues up to a year, up to 18 months, sometimes even up to 2 years, as a qualified medical evaluator fiddles around with not answering the questions that are posed by the parties and not resolving the disputed issues upon which the case hinges. And so these delays dramatically drive up costs, both in recurring medical legal costs, where the qualified medical evaluator is requested to provide a supplemental report or a new face-to-face evaluation, or requires that the qualified medical evaluator be deposed. Meanwhile, the injured worker / examinee is continuing off work on total temporary disability during the time of this delay of the resolution of the disputed issues, and it's a big problem. It's a big problem, and the Division of Workers' Compensation is going to start attacking QME reports in 3 main areas associated with 3 laws, one of which is a labor code and 2 of which are codes of regulation. So in today's discussion, I want to go through these laws with you so that you can get a heads up, so that you can get advance notice of the scrutiny and the specific lens through which the Division of Workers' Compensation is going to review your report, so that you can correct your report, so that you can shore up your report, so that you can improve your reports, so that your reports can survive the scrutiny by the Division of Workers' Compensation, and therefore you as a qualified medical evaluator can succeed greatly with a flood of new cases as more and more qualified medical evaluators discontinue their participation in the system simply because it's just proven to be too difficult for them to produce reports sufficient to satisfy the Division of Workers' Compensation. So with that as our introduction, let's begin today's discussion on Part 3 of the New Era Qualified Medical Evaluator. Okay, so I have a lot to go over with you in today's program, so let's get right down to business. The state auditor, as part of their accusations of the Division of Workers' Compensation, has claimed that the Division of Workers' Compensation has not tracked when judges rejected reports that failed to meet standards such as accuracy or completeness. So I want you to imagine that the parties are in front of the workers' compensation judge at a settlement hearing conference, okay? And up comes the qualified medical evaluator's report, and the judge is unable to use the report to resolve the disputed issue. Like what? Like such as the extent of permanent disability, such as the apportionment of the permanent disability or other issues. Well, what happens? What happens in this case? Well, typically the judge will order what's referred to as a development of the record, a development of the record. And what a development of the record is an opportunity for the parties to go back to the qualified medical evaluator to obtain a supplemental report to resolve or provide greater clarity on the disputed issue. So that creates a new delay. Can you imagine that? The parties are at the conference, the settlement conference, to settle the matter, but a new delay is introduced for the qualified medical evaluator to bring up his end of the stick so the parties can actually resolve the disputed issue. So there's a new delay. Well, also in these scenarios, the judge has another option. The judge has another option of ordering a new evaluator or a new evaluation and dismissing the qualified medical evaluator if, in the judge's opinion, the qualified medical evaluator is not able to resolve the disputed issue. For example, I recently read a case where the qualified medical evaluator, as part of his conclusion for permanent impairment, the qualified medical evaluator refused to provide a consideration of an alternate impairment rating under Alvarez and Guzman, which is now required. We're required as part of our permanent impairment opinion and conclusion to give consideration to an alternative impairment rating under Alvarez and Guzman. Doesn't mean we have to provide an alternative impairment rating under Alvarez and Guzman, but we're required to demonstrate to the parties that we've considered a range of alternative impairment ratings, and we've decided against those alternative impairment ratings because the impairment ratings under the strict application of the AMA guides accurately describe the examinee's impairment. So in this particular case, the qualified medical evaluator refused to consider an alternative impairment rating under Alvarez and Guzman, so the judge simply ordered a new evaluation and a new evaluator. So can you see the delay? The delay that these faux pas by the qualified medical evaluators introduce into the system? Well, now the DWC is in increased and new communication with judges to establish a better system whereby the judges can report to the Division of Workers' Compensation those reports, those qualified medical evaluators reports that do not resolve the disputed issues, so that the Division of Workers' Compensation can then act on those reports and then can act on or act with the doctors who authored those reports. So the Division of Workers' Compensation is newly developing their system to work with the judges, and they're going to be introducing at least three laws that govern the QME's report, and they're going to be scrutinizing reports in the beginning based at least upon these three laws. So let's go over these three laws and share how these three laws impact our reports. So the first of which is Labor Code 139.2 D2, CCR 10606, and CCR 9793, Section H, Section 3. And these aren't the only laws, meaning labor codes and codes of regulation, that govern the production of QME reports, but these are the initial laws that are being initially proposed by the Division of Workers' Compensation that judges can use to look into QME's reports to determine the quality and the ability of those reports to resolve disputed issues. So let's take a closer look at each of these laws. Okay, so here is a copy of a form that's being proposed by the Division of Workers' Compensation to be used by judges to report inadequate QME reports. And let's just read from this form together. This is a form that the judges will fill out. So it has here the name of the applicant, name of the defendant. In other words, this is the case in general here. And this is a finding and an order by the judge which rejects the medical report under Labor Code 139.2. So the judge will simply fill this out and inform the DWC that the above referenced matter came on for hearing as it was either an expedited hearing, maybe it was a mandatory settlement conference, adequacy hearing, approval of settlement, whatever. The judge will simply put a check in the appropriate box, and the judge will then select from one of the following three statements. For example, under Labor Code 139.2, the judge can inform the Division of Workers' Compensation that during the course of the proceedings, as a result of a review of the medical report of QME, name goes right here, dated such and such goes right here, the court finds that said report is in violation of Labor Code 139.2. The court hereby makes a finding rejecting the report for the following reasons, and herein the workers' compensation judge will fill in the reasons as to why the report was unable to resolve the issue at dispute at the expedited hearing, at the mandatory settlement conference, at a lien conference, etc. Okay, so that's deficiencies under 139.2, which we'll review in just a moment. Or the judge may determine that pursuant to Title 8, CCR 10606, that the report does not meet minimum standards, and we're going to go over those minimum standards in just a minute, because, and then ABC, the judge will list the standards that the qualified medical evaluator failed to comply with. Okay, so there's two laws that govern the production of the QME report. And then the judge may decide alternatively that neither of the two prior laws were operative in the QME's deficient report, but perhaps pursuant to Title 8, California Code of Regulations 9793, in considering the substance as well as the form of the report as required by applicable statutes, by applicable regulations, and by applicable case law, the report is not capable of proving or disproving a medical fact because the report does not constitute substantial medical evidence. The report fails to constitute substantial medical evidence because, and then the judge here will list the reasons why the qualified medical evaluator's opinions and conclusions are not opinions and conclusions that the court can rely upon, because the qualified medical evaluator has not qualified those opinions and conclusions as substantial opinions and conclusions. So in today's discussion, we're going to go into just some cursory detail into some quick steps that you can implement in your very next report to qualify your opinions as substantial opinions that can be relied upon by the judges to resolve disputed issues. Okay, so we'll get into that at the conclusion of today's program. For now, let's go into these three laws and read from the exact language of each of them. Okay, so first let's read from Labor Code 139.2 D2, which is specifically referenced in the document that we just reviewed. Now, Labor Code 139.2 Section D2 has to do with our reappointments as qualified medical evaluators. So imagine that you've just served a 2-year term as a qualified medical evaluator, and you receive your reapplication packet in the mail, and those typically come about 8 weeks prior to the last date of your 2-year term as a qualified medical evaluator. Well, one of the conditions upon which your reappointment will be processed, positively, favorably processed to reappoint you as a qualified medical evaluator, is if you have not had more than 5 of your evaluations that were considered by a workers' compensation administrative law judge at a contesting hearing rejected by the judge or by the appeals board pursuant to this section during the most recent 2-year period during which you as a physician served as a qualified medical evaluator. If the workers' compensation judge or the appeals board rejects the qualified medical evaluator's report on the basis that it fails to meet the minimum standards for those reports established by the administrative director or the appeals board, the workers' compensation judge or the appeals board, as the case may be, shall make a specific finding to that effect and shall give notice to the medical evaluator and to the administrative director of the Division of Workers' Compensation. And they're going to make that specific finding and give that specific finding to the qualified medical evaluator and to the Division of Workers' Compensation using the form that we just reviewed in the prior 2 slides. Okay? So the workers' compensation judges and the appeals board is now going to have a new incentive and a new directive by the Division of Workers' Compensation to do a better job at tracking these deficient reports Whereas up till now, both the judges and the Division of Workers' Compensation, through no fault of either of their own specifically, have become somewhat, I think the state auditor accused them of being, a bit deficient, a bit lackadaisical. And you can see that this procedure is going to require some work, especially on the part of the judges. But now the judges are going to have new directive from the Division of Workers' Compensation to make that specific finding, using the form that's been newly developed, and then to provide that specific finding to the administrative director and also to the qualified medical evaluator. And if the qualified medical evaluator has 5 such reports determined to be deficient, that is going to significantly interfere with a smooth reappointment process. Okay, so that's Labor Code 139.2. What about CCR 10606? This is a labor code that deals with a topic referred to as the physician's report as evidence. And it details what elements are required to be in the physician's report for the physician's report to qualify as evidence upon which disputed issues can be resolved. So this code tells us that the Workers' Compensation Appeals Board favors the production of medical evidence in the form of written reports. So what does that mean? That means that direct examination of a medical witness, meaning us as qualified medical evaluators, will not be received at a trial except upon a showing of good cause. So we as qualified medical evaluators provide our testimony in the form of written reports. Written reports take the form of initial QME reports, take the form of supplemental reports, take the form of reevaluation reports, and take the form of a written report which is extracted from deposition transcripts. So deposition transcripts qualify as written reports. So the parties collect our testimony, meaning our opinions and conclusions, in the form of written reports. And direct examination of us will not be received except upon a showing of good cause. So the written reports are extremely, extremely important and pivotal in the resolution of disputed issues. So that being the case, 10606 tells us that medical reports should include the following minimum elements. Number 1, the date of the examination. And if you're listening to this program, does your report contain the date of the examination? It must contain the date of the examination, because many of the benefits provided for under the California Workers' Compensation System are timeline driven by timelines, and thus the date of your evaluation is a critical timeline component. Must include the history of injury, must include the examinee's complaints. With regards to your review of records, it must contain a listing of all information received in preparation of the report, or a listing of all information relied upon for the formulation of the physician's opinion. So this has to do with your review of records, and we've talked before at great length about what constitutes an actual review of records. It must include the patient's medical history, including a history of the injuries and conditions, and any residuals that may result as a result of those injuries and conditions. It must include the findings on examination. It must include a diagnosis. It must include an opinion as to the nature, extent, and duration of disability and work limitations. And this is referring to both permanent disability and also referring to temporary disability. It must provide an opinion as to the cause of the disability, in other words, the apportionment of the disability between industrial and non-industrial factors. It must include a discussion of the treatment indicated, including past, continuing, and future medical care. And I suspect that this labor code will be updated in the future to consider that qualified medical evaluators do not resolve medical treatment disputes. However, nothing prevents a qualified medical evaluator from providing an opinion on the need for future medical care. Must also include an opinion as to whether or not permanent disability has resulted from the injury, and whether or not the examinee's condition is permanent and stationary. If the examinee's condition is permanent and stationary, the report must include a description of the disability with a complete evaluation of the disability. It must include an apportionment determination of the approximate percentage of the disability due to the industrial injury and the approximate percentage of the disability due to other factors. It must include the reasons for the opinion, and this is critical. It must include the reasons for the opinion, and then it must include the signature of the physician. So in the rest of today's program, or later on in the program, we're going to talk about this particular requirement, the reasons for the opinion. And it's the reasons for the opinion, not just the opinion. It's the reasoning behind the opinion that allows the courts to determine whether or not the qualified medical evaluator's opinion qualifies as a substantial opinion upon which the courts can actually resolve disputed issues. So the court needs from us not only opinions, needs our opinion. For example, our opinion that 10% of the disability is due to the industrial injury and 90% is due to other factors. That's the opinion. The courts also need to have our reasoning behind the opinion so that the court can determine how we arrived at the opinion, and the court can determine if that opinion is an opinion that qualifies as a substantial opinion upon which the disputed issue can be resolved. So we'll talk a little bit more at the end of today's discussion about what it takes to qualify your opinions as substantial medical evidence. Okay, but before we do that, let's talk about CCR 9793. Okay, so here's CCR 9793, and let's read this Section H, Section 3 in its entirety and understand what this actually implies in relation to deficient QME reports. And this section of the law deals with what qualifies as a medical legal expense. Now, what we bill for our QME reports is a medical legal expense. Well, the compensability of that medical legal expense is based upon satisfying several criteria as follows. So let's read this. It tells us that a medical legal expense means any costs or expenses incurred by or on behalf of any party or parties, on behalf of the administrative director or on behalf of the appeals board for x-rays, for laboratory fees, for other diagnostic tests, for medical reports, for medical records, for medical testimony, and as needed for interpreters' fees for the purpose of proving or disproving a contested claim. So this section of the law tells us that the purpose of medical legal expenses, the reason that those expenses are incurred is because those expenses are necessary costs for the purpose of proving or disproving contested claims. Now, if the workers' compensation judge rejects your report as insufficient or incapable of proving or disproving a contested claim, then that report no longer qualifies as a medical legal expense and does not need to be reimbursed under this section. And it tells us so. The cost of medical evaluations, diagnostic tests, and interpreters is not a medical legal expense unless, number one, it's incidental to the production of a comprehensive medical legal report or a follow-up medical legal evaluation report or a supplemental report, and all of the following conditions exist. Number one, the report is prepared by a physician, such as us, the qualified medical evaluator, and this is an easy section to satisfy. Number two, the report is obtained at the request of a party or parties. In other words, don't go producing reports without a request of the party or parties, because that report would not qualify as a medical legal expense. The report is obtained at the request of the administrative director or the appeals board for the purpose of proving or disproving a contested claim, and addresses the disputed medical fact or facts specified by the party or parties or other person who requested the comprehensive report. So reports that fail to address disputed issues and fail to resolve disputed issues do not qualify as medical legal expenses and do not need to be reimbursed as medical legal expenses. Finally, the report is capable of proving or disproving a disputed medical fact essential to the resolution of a contested claim, considering the substance as well as the form of the report as required by applicable statutes, regulations, and case law. So these are stiff criteria that have always existed, but the Division of Workers' Compensation may have been somewhat lax in enforcing the requirements of CCR 9793, but now through new communication and enhanced directives to the judges, the Division of Workers' Compensation is going to be denying payment for those reports that fail to resolve disputed issues, and is going to be challenging the qualified medical evaluator's reappointment for a new 2-year term if the administrative director collects 5 such reports of rejected QME reports from the workers' compensation judges. So a lot of proving and disproving disputed medical facts and resolving disputed issues has to do with the qualified medical evaluator's report and its ability to qualify its conclusions as substantial medical evidence. So let's talk about substantial medical evidence and what it takes to improve the content and quality of your opinions and conclusions so that those opinions and conclusions can be used in the resolution of disputed issues. Okay, so let's talk about substantial medical evidence. Now, substantial medical evidence is a fascinating topic. And once you become familiar and fluent with qualifying your opinions and conclusions as substantial medical evidence, you'll wonder why everyone in the world, and why every industry in the world, and why every vendor and provider in the world does not adopt this as their operative principle when providing opinions and conclusions. And so let me give you an example. Maybe you can relate to this. And I want to ask you how much sense this would make, this concept of substantial medical evidence, in the following example. Let's say, for example, you called a vendor out to your home to do a roof inspection. And after poking around your roof for about 15 minutes, the vendor comes and knocks on your front door and informs you that you need a new roof. Okay? So in other words, as a result of his inspection, or maybe we could say as a result of his examination, in order to analogize to the type of work that we do, After he does his inspection or examination of your roof, he then comes to you with his opinions and conclusions, much as we do in providing our QME reports. We provide opinions and conclusions. Well, in this case, the opinion that you need a new roof is only one component of the overall conclusion. This opinion that you need a new roof qualifies as what's referred to as the conclusory portion of the opinion. It's the conclusion of the opinion. Now let me ask you, as a homeowner, when the vendor comes to your front door and informs you that you need a new roof and the cost for the new roof is going to be $25,000, naturally, what would be your next natural reaction in this scenario? The roofing specialist comes to you and informs you with a conclusory opinion that you need a new roof. It's going to cost $25,000. What's your natural reaction? Okay, and this applies as to whether you're having a roof inspection, a car repair, a medical appointment. The scenarios are basically endless. Your natural reaction next is going to be, why? Why? Why do I need a new roof? Why do you conclude that I need a new roof? Upon what evidence do you rely in coming to the conclusion that I need a new roof? In other words, you're going to pursue the how and why reasoning behind the conclusory portion of the opinion. Let me give you another example. The conclusory opinion. Imagine you're at a Sunday afternoon barbecue, you're having some hamburgers and some beer or a drink, and one of your friends makes a conclusory opinion that says the 49ers suck. Okay? He provides you the conclusory portion of the opinion. Now, what's your natural reaction going to be? Your natural reaction is going to be, well, why do you say that? Upon what facts do you rely in coming up with the conclusion that the 49ers suck? Now, some barbecue party attendees will not be able to support their opinion and conclusion, and they'll say simply things like, well, they just suck, they're terrible, they lose every year, or something like that. Whereas a more informed football fan or fanatic will provide reasoning to support the opinion and conclusion. They'll say things like, well, the quarterback Jim Jones has a quarterback ranking of .02749, next to last in the league. And the defense has a stop statistic of 1.377, which is 18th in the league. And the opinion and conclusion will be supported with how and why reasoning that is factual, that is actual, that is true, that is accurate, upon which the opinion that the 49ers suck has some substantial basis backed up by fact. Okay? So in order for a conclusory opinion to qualify as a substantial opinion, the conclusory opinion must be backed up with certain elements in California workers' compensation. And we're going to talk about those elements here. Well, in the Gatton case, if you've been around a while, you remember the Gatton versus Yeager construction case. They told us that any decision of the board, all the decisions of the board must be supported by substantial evidence. Well, the medical reports that we provide to the courts form the basis upon which many resolutions are based. And those resolutions can only be based and can only occur when the opinions and conclusions of our reports qualify as substantial opinions. So you cannot just provide the conclusory portion of the opinion. The opinion must be supported with some how and why elements, which we'll talk about here. So the Gatton court told us that in order to constitute substantial evidence, A medical report must, number one, be predicated on reasonable medical probability. Reasonable medical probability. This means that the opinion is 51% probability of being correct. It's more likely correct than not. So, how do you qualify your opinions and conclusions as reasonable medical probability? You do that by sitting down and, first of all, drafting your opinion and conclusion, and then asking yourself, is this opinion or conclusion 51% or greater probably true? Is it 51% or greater probably true that the 49ers suck? Is it 51% probably true that I need a new roof? Is it 51% probably true that 10% of the permanent impairment is due to the industrial injury and 90% is due to other factors? You sit down and you think about your opinion and conclusion, and you ask yourself, is this thing 51% or greater probably true? If, in your opinion, the opinion and conclusion is 51% probably true, then you qualify that opinion by informing the parties, in my opinion, comma, within reasonable medical probability, comma, and then you state the opinion. So you predicate your opinion on reasonable medical probability within the body of your report. That's step one, qualifying your opinion as substantial medical evidence. Also, a medical opinion is not substantial. So if we can learn why an opinion is not substantial, then we'll know why an opinion is substantial. So it's not substantial if it's based on facts no longer germane, if it's based on inadequate medical history or examination, if it's based on incorrect legal theories, or if it's based in any way on surmise, speculation, conjecture, or guess. Further, a medical report is not substantial evidence unless it sets forth the reasoning. What are the reasons I need a new roof? What are the reasons? Now, you would expect the roofing contractor to come to you with the reasons why you need a new roof. You're missing shingles in the back. The flashing on the side is totally destroyed. It's been missing for probably the last 3 to 4 years. The gutter around back by the patio is leaking down through the plywood and into the substructure and subframe, and I'm making all this stuff up because I'm not a contractor. But you would expect the roofing contractor to come to you with reasons. And the reasons better be good for you to come forward with $25,000 for a new roof. Similarly, in the work that we do, the reasons have to be good. They have to be based on germane and relevant facts. They have to be based on a beautiful and thorough history. They must be based on an adequate examination, which is an examination that exactly complies with the descriptions of measurements and methods in the AMA guides. That's what qualifies as an adequate examination. If you're doing an examination out of your clinical practice, using measurement techniques and orthopedic tests out of your clinical practice that have no relevance and no reference in the AMA guides, that does not qualify as an adequate examination, and the opinions and conclusions upon which that examination contributes, the extent to which that examination contributes to your opinions and conclusions would not qualify as a substantial opinion or conclusion because the examination is not an adequate examination. And then finally, many times qualified medical evaluators, when they provide their opinions and conclusions, those opinions and conclusions are basically just conjecture. They're just throwing out numbers. They're not based on any relevant facts. They're not based on anything substantial. They're just conjecture. And once you become aware of this topic, you'll become more attuned and aware of how often people provide opinions and conclusions, even yourself, or maybe even your spouse or your loved ones, provide opinions and conclusions simply based on conjecture that have no basis in anything substantial whatsoever. So now that we know this, I'm going to show you how to incorporate these requirements into the body of your report. Okay, so just one more reference about substantial medical evidence, and this comes from the Escobedo case. And the Escobedo case was basically involved in the apportionment determination and how to qualify the apportionment approximate percentages as substantial medical evidence. So the court told us that to be substantial evidence on the issue of apportionment, this relates to apportionment. The Escobedo case was about apportionment, but the same concept applies to every single opinion and conclusion that you offer in the body of your report, not just your opinion and conclusion on apportionment. So in order to qualify as substantial evidence, a medical report must be framed in terms of reasonable medical probability. It must not be speculative. It must be based on pertinent facts and on an adequate examination in history, and must set forth reasoning in support of its conclusions. And let's see how we would do just such a thing. Okay, so let's see how to do that within the body of our report. And in moving forward and considering the new era of the qualified medical evaluator, based upon the Division of Workers' Compensation's new scrutiny on our reports, we know that based on CCR 35.35, and as we discussed in several of the laws and labor codes that we discussed earlier in today's program, that the judges are going to be relying upon in evaluating QME reports, we know that the qualified medical evaluator shall address all contested medical issues and shall address all questions posed by the parties in the cover letters that we received. So imagine that you receive a cover letter that requests apportionment. How do you handle the addressment of the apportionment question posed to you by one or more of the parties? How do you handle that within the body of your report in such a way that your opinion and conclusion qualifies as substantial medical evidence and therefore can actually be used by the parties in the resolution of disputed issues? You see, the qualification that our opinions meet the high standard of substantial medical evidence is not something subjective being imposed upon us by the will of the parties. It's a requirement at the court that the opinion, okay, if we just look at an opinion like this, as it actually has form and mass to it, the opinion must be what's referred to as a substantial opinion. So the parties look at the opinion. In other words, they don't look at the conclusory portion of the opinion first. They look at the opinion, whatever it may be, A, B, C, D, E, M, E, L, M, N, O, P, whatever the opinion is. And they look at the opinion and they see if the opinion qualifies as a substantial opinion. If it qualifies as a substantial opinion, meaning it meets the criteria, then the parties can then look to the conclusory portion of the opinion. 10% of the permanent impairment is due to the industrial injury and 90% is due to other factors. They can look at the conclusory portion and they can use the conclusory portion because the conclusory portion is supported by the substantiability of the opinion. So the opinion, if it doesn't qualify as substantial, the parties look at it and it doesn't have the form and the mass and the substance of a substantial opinion, it can't be used. Nothing personal. It's just that the opinion can't be used because it's not a substantial opinion. So in this example, we get a cover letter from the parties requesting a resolution of the apportionment disputed issue. How do we handle it? Let's go into that. So here's how I suggest that you can handle that moving forward into the new era. such that you address all the questions posed by the parties and that you actually resolve the issues in dispute by the parties by providing an opinion and conclusion that qualifies as substantial medical evidence. So in this case, we have a cover letter from one of the parties requesting an addressment of apportionment. So what you do in the body of your report is you go to the apportionment section of your report, where you have a topic heading in bold that says apportionment. And it's in this section that you're going to discuss all issues related to apportionment. Well, the very first thing in this apportionment section, you want to reiterate the question that was posed by the party. So in this case, you would say apportionment. Drop down 2 lines, and you would say, the January 1st, 2020 cover letter from Betty Sue of ABC Insurance Company requests, drop down, and then using a bullet point, you type the exact question word for word posed by the party. In this case, she asked, please state the percentage of disability due to industrial factors and the percentage due to any pre-existing disability or any disability due to the natural progression of non-industrial factors, blah, 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 whatever. It's an apportionment question. The point is you cite exactly the question as it's posed to you by the party. And then what you want to do is you want to answer that question exactly the way that it's addressed by the party. You don't use circumlocution, and you don't go around the issue and dodge the issue or answer it in words that causes the party to have to delve in there deep and think about what the heck it is you're trying to say. You strive as much as possible to answer the party's question in the most direct language that mirrors the language with which they used to ask you the question. In this way, you can satisfy the party that you're addressing their question and answering their question in the manner that they would like to have you answer the question. Okay? And let's see how that looks in the body of the report. So then below the question that's posed to you by the parties, you give them your answer. And it goes like this. You type in the word answer. That alerts the party to the fact that the following is your answer to their question. You state, in my opinion, and within reasonable medical probability, and you've now satisfied step number 1 in qualifying your opinion as substantial medical evidence, in that you've predicated it on reasonable medical probability. And then you answer her question in the exact words that she used in posing the question to you. You tell her that such and such percent of the permanent impairment is due to the industrial injury, and such of the permanent impairment is due to other factors. And then you qualify that opinion, that conclusory opinion, you then qualify it as a substantial opinion by letting the parties know that your reasons for this conclusion include the following. And then you reiterate that your opinion is based on reasonable medical probability. Number 2, that your opinion is based upon pertinent facts. And just like the roofing contractor that comes to your front door with a roofing estimate of $25,000 for a new roof, you elaborate on the facts upon which your approximate percentages of 10% and 90% or whatever your approximate percentages are based. You elaborate on the relevant facts, such as the mechanism of injury, such as response to medical care, such as the presence of pre-existing conditions, whatever the relevant facts are upon which your apportionment determination is made, goes here in this section of your answer. Okay, and this is what qualifies and elevates your opinion to an opinion that qualifies as a substantial opinion. And then you let the parties know that your opinions and conclusions are based on an adequate history and on an adequate examination. And if you've seen this particular examinee on several evaluation instances, you would let them know that it's based on an adequate history and examination of Mrs. Jones on 3 occasions, and then provide the dates of those 3 occasions. And it's this type of elaboration that impresses the parties that you have an adequate understanding of the examinee's history, and that on repeated face-to-face evaluations, you have a good understanding of the examinee's actual condition through repeated exposure to the same examinee. Then if you have any additional how and why reasoning that would provide support to your opinion and conclusion on the apportionment approximate percentages, you would provide that additionally in this portion of your answer. And then finally, let the parties know that there's no speculation involved, and you can simply do that by putting a statement in the report that the above opinion on apportionment approximate percentages is not based on guess, speculation, surmise, or conjecture. And when you finally provide this last statement, only provide this last statement when you have sat down and thoroughly contemplated every aspect of your reasoning to support this opinion and conclusion, and confirm to yourself first that not a single portion of the opinion or conclusion is in any way based upon guess, speculation, surmise, or conjecture. Now, doctors, this is not easy. This is not easy to do, and many qualified medical evaluators are not going to be able to do this. They cannot do this. They do not possess the medical decision-making skills to qualify their opinions and conclusion as substantial medical evidence. And that is not meant in any way to downgrade or denigrate these qualified medical evaluators, because this is not everyone's bag. In colloquial terms, I can just say that doing qualified medical evaluations and writing difficult and detailed medical reports is not everyone's bag. Not everyone is suited to it. And I've spoken to many qualified or ex-qualified medical evaluators who have given up their QME credential in favor simply of treating patients because they've concluded that it's just not their thing, and it's not everyone's thing, and not everyone who's currently a qualified medical evaluator is going to be able to adequately address and resolve disputed issues. Well, if you can address and resolve disputed issues by qualifying your opinions and conclusions as substantial medical evidence, and by shoring up your reports to satisfy the Division of Workers' Compensation that your reports actually qualify as high-quality reports, you stand to benefit greatly by the coming avalanche and flood of new cases that are going to become raining down on you as more and more QMEs leave the system because they've simply concluded that it's not their bag. Well, you can capture the whole bag for yourself if you adopt these simple procedures into your very next evaluation. So doctors, I hope this helps you. It's my opinion and conclusion based upon the recent developments at the Division of Workers' Compensation that great opportunity is upon us. And I've shared with you in our first 3 sessions of this program exactly how, with some meat and potatoes procedures and some nuts and bolts actual procedures, I've shared with you how you can capitalize on the new era that is now upon us. So doctors, I hope this helps you, and I want to thank you for taking the time to join me on today's discussion. I look forward to being with you on our very next discussion as we continue our ongoing series entitled The New Era Qualified Medical Evaluator. For now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.